In the last video on mortgages, we talked about the rights that were available for mortgagors, such as the equity of redemption and also what happens in cases of misrepresentation and undue influence. But in that video, we also talked about how mortgages is all about getting a balance between mortgagors on the one hand and mortgagees on the other. So with that in mind, we're going to focus this week on the rights that are available to mortgagees, often the bank. So let's get started with that then. The first question that we can ask then is what type of protection is available to mortgagees? And I've just taken the time to list those down here. So we've got 4 key ones that spring to mind, and all we're going to do in this lecture is go through each of them in turn. So let's start off with pre-existing equitable interests. And this is where the bank has a mortgage charge over a property. We have the gentleman there who has a legal interest in the property, but it may well be that his wife and also potentially his children have an equitable interest in the property. And the problem with that in the past was that this equitable interest of the wife and the children would be able to override the bank's interest in the property. And this was most famously demonstrated in the case of Williams and Glyn's Bank and Boland, and to an extent it created a degree of uncertainty in the law, and for banks meant that their mortgage charges over property was not exactly a safe commercial bet in certain circumstances. However, since 1981 there has been very much a retreat away from this Boland principle, most notably seen in the case of Abbey National Building Society in Cann 1991, but there have been other cases as well. I'm sure in a future lecture I'll have a chance to go over overriding interests in more detail, but for the time being we just need to refer to Schedule 3, Paragraph 2 of the Land Registration Act 2002, and this states that overriding status is only available where the equitable interest actually subsisted at the time of the disposition itself, and the occupation of the property was obvious on a reasonably careful inspection of the land at the time. So it limits those circumstances where the equitable interest will actually override and therefore helps mortgagees to a great extent. To give you an example of actual occupation, in Abbey National in Cann, Mrs. Cann was on holiday at the time of the disposition, and so her actual occupation of the property was not obvious as per the 2002 Act. Things become even easier for the mortgagees where there is more than one trustee of the land. If there's 2 or more, then the mortgagee overrides all beneficial interests, and that comes from the case of City of London Building Society and Flegg 1988. If you are answering an essay question on this area, it's quite an interesting and debatable topic because this has certain connotations in relation to Article 8 of the European Convention on Human Rights, the right to private and family life. And there have been a couple of cases since 1988 where Flegg has been sort of half challenged on the basis of Article 8, but there's not been a proper discussion of the case, and so for the time being that principle stands where there is more than one trustee of land. The cases of fraud are relatively rare nowadays, but it may be that if you're answering a problem type scenario, the tutor has thrown one in to try and sort of catch you out. This is where we have one trustee of land who forges the signature of another trustee of land, and the most likely thing that would happen in that scenario is that the joint tenancy over the property would be severed. The person who has been defrauded would get to keep their share, but the fraudster's share would be taken over by the bank. It would then be very likely that the bank would apply to sell the property so that they would have a return on their investment. A little bit harsh on the person who's been defrauded, but as I say, this situation is very rare nowadays because of the checks that are in place. So moving on to subrogation, again we can return to this situation where the bank has a mortgage charge over the property, but we have a person who comes in this situation, and for copyright reasons we'll call them Mr. Snrub, and this person decides that they actually want the charge over the property. So Mr. Snrub can give the bank money in return for the charge over the property, And so subrogation is basically the principle where this happens. So the bank moves out of the way, and then Mr. Snrub has a charge over the property instead of the bank because he's paid to do so. It doesn't really affect anything for the mortgagor in terms of the agreement, but it's just a question that the Mr. Snrub will have paid off the mortgage essentially in order to take over the charge himself. Excellent. So one of the things I talked about is, as well as immunity from leases. This isn't universal because the mortgagee is bound by any lease created prior to the mortgage, as per Neal and Mackenzie in 1836. But they're not affected by any lease after the mortgage is granted. That comes from Rogers and Humphrey. There may be certain situations where there is a statutory lease and that might be binding, but those examples are particularly rare and not something that you should worry too much about. The right to grant leases is often excluded by the mortgage agreement anyway, and so in real life situations this rarely comes up as an issue, but again it's another protection that is available to the mortgagee. Last and but by no means least, probably one of the most important rights is the right to immediate possession. And to give you an example of just how powerful this right of the mortgagee is, according to Justice Harman in the Four Maids case, that mortgagee may go into possession before the ink is dry on the mortgage unless there is something in the contract whereby he has contracted himself out of that right. So if the mortgage agreement itself makes no reference to any sort of default or other trigger for possession, then the mortgagee could basically go into possession straight away. Now, obviously, in most situations and almost all situations nowadays, the mortgage agreement itself will actually exclude the right to possession until there is actually some default by the mortgagor. So if the mortgagor is saying this is 3 payments on their mortgage, then the mortgage agreement might then say, well, in those circumstances, the mortgagee can go into possession. And we saw that from the Birmingham Citizens Permanent Building Society and Cann case in 1962. However, the actual incentive for the mortgagee to go into possession is actually relatively limited. When you think about this first off, it sounds like a fantastic opportunity for the mortgagee to basically say, all right, you've missed a payment, I'm going to go into possession of your property and just basically seal things up like some sort of Victorian landlord or something like that. The reality is much different because there are a lot of obligations that the mortgagee has to go by when they actually do take possession. So they have to account to the mortgagor for rents and profits as per Lord Trimleston and Hamel in 1810. Meanwhile, the mortgagee may not actually derive any profits themselves, so there's not really any financial incentive for a bank to go into possession of a property. If anything, it's going to be more of a drain on their resources and just be a little bit of an annoyance, to be honest. Furthermore, there are other duties to take reasonable care of the property, for example, and let the property at proper market rent. That's per Vice-Chancellor Nichols in the Polk case. And also, if they don't do a very good job, then they have to account for income that would have been received if it had been managed properly, as per White and City of London Brewery in 1889. So there's a couple of other things that we can finally mention in relation to immediate possession. Obviously, this is a great deal of stress possibly for the mortgagee, but they do have a statutory power to appoint a receiver under section 101(1)(3) of the Law of Property Act 1925, and we'll talk about that a little bit next week. But also, it may be relevant to mention that criminal law can often come into this as well. So they cannot use or threaten violence to gain entry if the person is present and is opposed to that entry. And so we can look at section 6.1 of the Criminal Law Act 1977. So this right to immediate possession on the surface sounds really powerful for the mortgagee. The reality of the situation is that there are a number of checks and balances in place that make sure that the mortgagee doesn't abuse that right and just turn up at a homeowner's house one day and ask them to put the kettle on and wipe their feet on the way out of the door. So I know that I keep talking about this and I'm probably beginning to sound like a broken record, But mortgages really is all about that balance between the mortgagor's right and the mortgagee's right. And in order for you to get the most marks that are available on any problem question, you're going to have to consider both sides of the argument. It may be a situation where you have a mortgagor who has an equitable interest in the property, but the mortgagee is able to override that interest, as we saw this week. Furthermore, the mortgagor may have a right to redeem as per last week's lecture, but that may be curtailed by certain rights of the mortgagee as well. So for each different aspect of any problem question, we are making sure that we consider both sides. Now, next week we're going to cover remedies, so make sure that you also watch part 3 of this series. In the meantime, make sure to leave a like for this video, click subscribe so you know as soon as that 3rd video on mortgages comes up, and if you've got any questions about the things that we talked about today, then make sure to leave those in the comments below. Thanks very much for watching, and I'll see you next week. Bye!